The first topic is nature and classification of companies. Nature and classification of companies. Nature and classification of companies. So this is the first topic that you are going to look at. So under this particular topic, what you need to be able to understand is the definition of a company. What is a company? The definition of a company. Definition of a company. So another thing you are supposed to understand are the characteristics of a company. Characteristics of a company. What are the characteristics of a company? It is important also to be able to understand the types of companies. Types of companies we have. Types of companies that we have. Another key one is the principle of separate legal entity. Principle of separate legal entity. The principle of separate legal entity and the veil of incorporation. Veil of incorporation. And also the last thing that we'll be able to learn under this particular topic is for you to be able to distinguish between a company. So the distinction between a company, and other forms of business and other forms of business. So I think I had already shared the notes. So what you can just be able to do here is maybe to do summary notes, because the notes I've already shared. After the previous class, I had actually shared the notes from, I think, topic 1 up to topic number 4. So when you talk about a company, as I had previously mentioned, what should actually be able to come to your mind first is that a company is a form of business. It is a form or means through which a person can be able to carry out business. So when you talk about forms of business, then what should come to your mind also is that we have other forms of business. For example, in this case, we could be able to talk about a sole proprietorship. We could also be able to talk about a partnership as a form of business. Maybe we could be able to also talk about a cooperative society. So these are the other forms of business. So what we simply mean is that a company will be one among them. A company will be one among these forms of business. It is a means through which a person can actually be able to carry out a business. So when you talk about a company, it is a form of business, and basically a company is an association of persons. These persons, they have maybe some skills. So they have some skills, or maybe we can talk about abilities, or maybe it could be talents. So these skills and abilities they have, we are saying an association of persons. It is an association of persons. These persons have skills, abilities, or talents. This coupled with resources. When you talk about resources now, we mean capital. Coupled with resources, these persons, they are able to provide goods or services to consumers. And the key aim, it is actually always to make what we call a profit. So what we mean by a company, as I've said, it is an association of people coming together. These persons, maybe they have some skills or abilities or talents. So these skills or abilities or talents coupled or basically conjoined with what we call resources, which is actually capital, they will be able to provide goods or services to consumers. And the main aim is normally actually to make what we call a profit. That is what we mean by a company. An association of persons coming together with certain skills or maybe abilities or talents. These persons, they have resources. These resources, they are actually able to use them with the skills or abilities to provide goods or services to consumers at what we call a profit. So that is what we mean by a company. I think the board should be looking a bit better now. So it should be looking a bit better now. So that is what we mean by a company, an association of persons coming together. These persons, they have certain skills, abilities, or talents coupled with resources, or maybe you can say capital. They are able to provide what we call goods or services to consumers. And the main aim actually, for example, in any form of business, is to make what we call a profit. That is what we mean by a company. So a company is actually a very unique form of business. It is actually a very unique form of business. So that's why certain times people might actually be able to prefer to just operate as a company rather than these other forms of business. So that brings us to actually, what are the characteristics of a company? What are the characteristics of a company? So the first dominant one is that a company is a separate, it is a separate legal entity. Number two, it is an artificial person. It is an artificial person. That is characteristic number two. Number three, it has the capacity to contract. A company has the capacity to contract. Number four, capacity to own property. Capacity to own property. It has the capacity to own property in its own name. Number five, it has what we call perpetual succession or permanent existence. Perpetual succession or permanent existence. That is characteristic number five. Another one you can actually be able to mention, for example, number six, it has what we call, it can have what we call a limited liability. So I'll be able to explain all of them. So we've said it is a separate legal entity. It is an artificial person. It has the capacity to contract, capacity to own property in its own name. It has what we call perpetual succession or permanent existence. It can have what we call a limited liability. Then also another thing is that a company will have what we call a common seal. It can have a common seal. It will have a common seal. So these are the characteristics of a company that make it to become a very unique form of business, whereby people will be able to prefer to operate as a company rather than these other forms of business. For example, the first one, we are saying that it is a separate legal entity. It is a separate legal entity. What we mean by this, it is that when a company is actually formed or comes into existence through a process known as incorporation, a company will be viewed as being a person on its own under the law. It will be viewed as being a person on its own under the law. So for every form of business, we have the owners of the business. We have the owners of the business. So in this case, when you talk about a separate legal entity, so the owners and the company itself will be viewed as being two different persons under the law. It will be viewed as being a separate entity from the owners. So in this case, when you talk about the owners, these are simply like, for example, the shareholders of the company. So you're a shareholder in a company, you are the owner of the company because you own a stake, or basically you have an ownership in that particular company. So what you should actually be able to know that a company always be viewed as being a person on its own. It should be viewed as being a separate entity from the owners. So this one is basically explained by a famous case law. It is known as Solomon. It is known as Solomon versus Solomon and Company Limited of 1887. So in this particular case law, it basically talks about this guy known as Solomon. So this person was of a Jewish origin. So Solomon. So he's of a Jewish origin. So this guy actually migrated to the United Kingdom. So he basically went there, and while there in the United Kingdom, this person of a Jewish origin, he set up a sole proprietorship form of business that was actually basically involved in manufacture of boots, or basically shoes known as boots. So as you know, a sole ownership, or basically a sole proprietorship form of business, it is a business that is owned by a sole person, or is actually owned by one person. So what actually happened while carrying out the business, the relatives basically got interested in this particular business. So they had an interest in the business. When you talk about the relatives, these are the children and of course the wife. So they got interested in this particular business. So what actually happened, Solomon basically converted this particular business from being a sole proprietor to becoming a company known as Solomon and Company Limited. So as a result of that, basically the Solomon himself and of course the children and the wife, they became shareholders or owners in the company. They became shareholders or owners in the company. But as the company was actually operating, this particular company known as Solomon and Company Limited, it faced financial difficulties. As a result, this company was actually forced to be liquidated. So what we simply mean by liquidation, so we are saying a company, for example, is an artificial person. When you talk about an artificial person, we simply mean that it is formed by another person or a natural person like me and you. It doesn't just come into existence from anywhere. There's a process. Also, when the life of the company is to come to an end, it is a process. So this particular process is what we are calling liquidation. And for example, a company can be liquidated, or the life of the company can come to an end as a result of financial difficulties. Tuskys' life has come to an end, or basically can come to an end as a result of financial difficulties. So basically Tuskys won't be in existence. That process basically to close off Tuskys, or basically to end the life of Tuskys, is what we are calling liquidation. So this is what this company was facing. Solomon and Company Limited was basically facing financial difficulties. So as a result of that, this company was actually forced to be liquidated. But one thing that actually comes out when this particular company was actually being formed, apart from Solomon being an owner, Solomon was actually given debentures in the company. I think they were worth £10,000 debentures. So what is a debenture? So a debenture basically can be given to you, or basically sold to you in case you basically lend a particular amount to the company. So what it simply means that apart from Solomon being an owner, Solomon was actually also a creditor to the company because he was given debentures worth 10,000. So what is a debenture? It is simply an authentication that clearly indicates a particular person is indebted to the company. Basically, the company owes him a particular sum of money. So this was as a result of Solomon having transferred all his properties, all his assets to the business that was actually being formed with the other relatives, which were the sons, or basically the sons, daughters, and the wife. So he didn't give out the assets for free to the company. Remember, this was a different form of business, a sole proprietorship form of business. But now it is being transferred to another form of business that had actually been formed, known as Solomon and Company Limited. So all the assets that Solomon was using to basically operate this particular business were transferred to the company. So as a result of that, he was given a higher stake. Apart from the shares, he was given debentures worth £10,000 in the company. What we mean by this, Solomon was entitled to be getting interest each and every year from the company as a result of having transferred assets worth £10,000 to the company. So you are saying the life of the company came to an end. And therefore, it simply means that when the life of the company is to come to an end, all the creditors, all those persons who had basically, for example, supplied items to the company, they must be paid off first before the life of the company can actually come to an end. So the suppliers to Tuskys basically have to be paid off their due amounts from this particular company known as Tuskys before the life of Tuskys can come to an end. So therefore, Solomon's life was coming to an end. All the creditors were supposed to be listed and be paid their due amounts from the company. So there was an argument that arose before the courts. So therefore, the other creditors were claiming that Solomon is actually an owner or a shareholder of the company. Therefore, Solomon is not entitled to be listed as a creditor in the company. Remember, we are saying Solomon was a creditor in the company because he had been given debentures worth £10,000. And you are saying when the life of the company is to come to an end, all the creditors, this company known as Tuskys, must basically be listed and be paid all their due amounts before the life of the company can come to an end or basically be dissolved from the register at the registrar's office. So other creditors in the company, Solomon had been listed, but other creditors in the company were claiming that Solomon is a shareholder in the company and therefore also an owner in the company. So Solomon and the company itself are just like one and the same thing. Therefore, why is it that Solomon should be listed as a creditor? So this argument went before the court. And of course, what was actually ruled is that always a company will be viewed as being a separate entity from the owners. Therefore, the conclusion was that Solomon has a right to be listed as a creditor as a result of the £10,000 worth of debentures that he had been given in the company. Therefore, always the company and the owners will always be viewed as being separate entities. The company is a person on its own, while the owners of the company are also persons on their own. The existence of the company doesn't depend on the life of the owners or the shareholders. In this case, we simply mean, for example, a shareholder at Safaricom, if he's not there, the life of Safaricom doesn't depend on the life of the shareholder of the company. In case of death, or basically if he loses life of Safaricom can still actually basically continue to exist, because a company is always a separate entity or a separate person under the law from the owners of the business. That's why a company is a very unique form of business, and most people will basically prefer to operate as a company rather than these other forms of business. Because if you look at, for example, a sole proprietorship form of business, this is a business that is actually owned by a sole person. And therefore, in case of death of this particular sole person, most probably the life of this particular business will come to an end. It's not the same case with a company, because a company is a person on its own from the owners. So that is the major key characteristic of a company that makes it to become very, very unique. So a company is always a separate legal entity. So I think you've gotten what we mean by a separate legal entity, that a company is a person on its own from the owners. The existence of the company doesn't actually depend on the life of the owners. So that is what we mean by separate legal entity. Number two, a company is an artificial person. So as I've told you, basically, a company does not just come into existence from nowhere. So there's usually a process that has to be undertaken by a natural person like me and you. That particular process we'll learn about later in a topic known as formation. So a company comes into existence through a process known as formation or incorporation. And this comes up as a result of a natural person basically having to undertake certain processes or basically certain procedures before the company can actually be incorporated. It is given a certificate to operate as a company. So that is what we mean by a company being an artificial person. So it is actually formed by a natural person through a process known as incorporation or formation or maybe promotion. A company has the capacity or the ability to be able to contract. So since a company is a separate entity from the owners, a company can actually always enter into contracts in its own name with other, for example, companies, with other, for example, individuals, or maybe with, for example, with the employees. In this case, if you are employed at Safaricom, basically that particular contract is between you, the employee, and Safaricom as a company. So since it is a separate entity, therefore it will have the capacity or actually ability to be able to contract, enter into business deals or basically business transactions with other companies. So it has the capacity or actually ability to be able to contract. If you look at, for example, this particular form of business known as a sole proprietorship form of business, that contract will basically be entered into in the name of the owner of the business, not in the name of, for example, like in the case of the company, whereby the contract will be entered into in the name of the company and not the shareholders. If Safaricom is to enter into a contract, they won't list there all the shareholders entering into a contract with another party. They'll simply clearly indicate it is Safaricom versus another company, for example, Airtel or maybe Telecom. So that's what we are saying. A company has the capability or actually capacity to be able to contract with other businesses, for example, other companies or other individuals, for example, employees, engage employees under contracts. So that's what we are saying. A company has the capacity or actually ability to be able to contract. A company has the capacity to own property in its own name. So in this case, we simply mean that if land is acquired it won't basically be registered in the name of the shareholders or the owners of the company. It will be registered by the Registrar of Lands in the name of the company itself. So if Safaricom is to acquire land or a property anywhere, the property won't be listed in the name of the shareholders, who might actually be even more than 1,000. It will be listed in the name of Safaricom as a company. In the case of a sole proprietorship form of business, or for example, a partnership, that particular property will be listed in the name of the partners. So not in the name of the business name of this particular partnership. It's not the same case with a company, because it is a separate entity or is viewed as being a person under the law. Therefore, any properties acquired by the company can actually be registered in the name of the company. That is what we mean by the capability or capacity to be able to own property in its own name. Number 5, a company has what we call perpetual succession or permanent existence. This simply means that since you've already said that the existence of the company or the life of the company won't depend on the life of the owners or the shareholders, a company can actually be able to exist for a very long period of time, even over a century. So long as basically the product they are providing, it is still actually basically being needed, the life of the company can actually just continue to exist, unless maybe, for example, if it faces financial difficulties or something has actually happened, it can actually be liquidated, or the life of the company can come to an end. But a company has what we call perpetual succession. So owners will come in, others will come in, and the life of the company will just continue. That's why basically you can actually be able to see that certain companies have been in existence for a very long period of time, even over a century. The founders are no longer there, but the life of the company is still actually going on. So basically there has been change of ownership, succession in the companies, and the life of the company is actually able to continue. So there are several companies we can actually be able to mention. For example, Coca-Cola has been there for very many years. So the founder of Coca-Cola might not actually be there, but Coca-Cola is actually still in existence. What are the chances that people are actually basically to stop taking soda in the near future? The chances are actually very minimal. So this product basically is still actually being consumed by the consumers. So it can actually exist for a very long period of time. So as a result of separate legal entity, there is actually just basically perpetual succession at Coca-Cola. And therefore, the existence of Coca-Cola as a company doesn't depend on the life of the owners or basically the founders of this particular company. A company like, for example, Bata. So Bata was actually founded by a particular person known as Bata. It is around 1875. So you can actually imagine up to now, Bata is actually still in existence. Bata is actually no longer there, but the life of Bata is actually still going on. So there has actually basically been what we call perpetual succession at Bata as a company. So that you are saying the existence of the company itself and the owner or the founder doesn't basically depend on each other. So since it's a company, is a person on its own, it is viewed as being a person on its own. Basically, it means that there's actually what we call perpetual succession or permanent existence. So what are the chances people are not actually basically not going to be using the shoes that are basically manufactured by Bata? So long as the products or services are still actually basically in need by the consumers, the life of the company can actually basically continue, or it can actually exist for a very long period of time. That's why we are saying permanent. It can be permanent existence. So it simply means that the life of the company might actually maybe not come to an end, so long as what is actually providing is actually still in need. So we've said unless maybe, number one, maybe the company has faced financial difficulties, or basically the company is being involved in outlawed activities, then it can be liquidated. But so long as the company is operating according to the requirements of the law, it can exist for a very long period of time, or we can have what we call perpetual succession, or basically change of ownership. Number 6, we are saying that a company has what we call a limited liability. It has what we call a limited liability. What we mean by a limited liability, and it will clearly come out when we be looking at the types of companies that you can actually be able to have. By a limited liability in a company, you can actually be able to tell the extent to which your liability can actually be. It is actually up to what extent. You can be able to tell your liability in the company. It is actually up to what extent. Is it up to maybe 10 shillings? Is it up to maybe 12 shillings? Is it up to maybe 100,000? So there's actually always what we call a limit. There can be a limit to your liability. in the company. What we mean by a limit to your liability, for example, if this particular company has failed to meet its obligations, you can actually be called on as an owner of the company or the shareholder to be able to maybe to contribute towards the assets up to a particular limit. The limit is already set. That's what you are saying. There's a limited liability. Your liability as an owner can actually go up to a specified extent or limit. It is not the same case with, for example, a sole proprietorship form of business. What we mean by this is that, for example, if this particular sole proprietorship form of business has not actually been able to meet its obligations, it doesn't matter. If the business itself does not actually have the capacity to pay off the liabilities, they can call upon you as the owner to contribute your own assets towards the expenses or liabilities of the business. But in this case, if you are a shareholder at Safaricom, basically maybe you own, like, for example, shares worth 100,000 shares. So in this case, it simply means that you can only be called upon up to that extent, up to the extent of your ownership in that company. But in the case of a sole proprietorship form of business or a partnership, it doesn't matter. It simply means that if this business is not actually able to meet its obligations, for example, paying the creditors, or basically, for example, paying a loan, they can actually be able to attach your assets as the sole owner of the business, your personal assets, not the assets of the business, your personal assets, to basically be utilized to pay off the expenses or the liabilities. It's not the same case in a company. For example, in Safaricom, you won't actually basically be ambushed, for example, by the creditors of Safaricom at your doorstep. They want basically to take over your assets because the company or Safaricom as a company has not actually been able to fulfill its obligations, because your extent has actually already been defined in a company. So your liability in a company is up to a particular extent. It can be defined. So that's what we are saying. It can have what we call a limited liability for you as the owner of the company. If it is up to 100,000 worth of shares you've acquired in that particular company, it is to that extent. They can't go beyond that particular extent. For example, attach your personal assets. So if Safaricom is to be liquidated, in this case, it simply means that your portion of contribution towards the assets will be worth 100,000. It is already defined. There's a limit. That's what we mean by a limited liability. So therefore, a company can be able to have what we call a limited liability. And at common sale, so since a company is an artificial person, it is not a natural person. For you, like a natural person, you can actually be able to authenticate your documents by simply having a signature. If you go to withdraw money at the bank, you can be able to use your signature. But a company is not a natural person. It is not actually able to sign its own documents. So it can only be able to authenticate its own documents by being able to use what we call a common seal, or sometimes in other places they use what we call a stamp. So that's why several documents issued by the company to authenticate or clearly indicate they have originated from the company, they'll always stamp them or basically use what we call a common seal. So it's simply basically an instrument used to authenticate documentation from the company. Maybe it could be an invoice, it could be a letter. You can easily tell it's originated from that particular company by simply being able to look at a stamp that has already been indicated on that particular document. So a company will have what we call a common seal because it doesn't have the capacity or capabilities to sign documents like a natural person. So these are some of the key characteristics of a company. So if you look at them, they're actually very unique. Therefore, you won't actually maybe find them in these other forms of business like a sole proprietor or a partnership. That's why I told you many people will be able to prefer to operate as a company rather than these other forms of business. So those are the characteristics of a company as a form of business, So I want us to start looking at the types of companies, You can say types of companies or classification of companies, types of companies or classification of companies. So we can be able to separate or categorize these particular classifications into two. So we have classifications under the Companies Act, classifications under the Companies Act, and we can have other classifications or general classifications. So under the Companies Act of 2015. So basically, the laws regulating operations of companies in Kenya is actually the Companies Act of 2015. So maybe it is good you have that particular act. When you make a particular reference, you can always be going back to check what you've been able to learn. So it's simply the law that regulates operations of companies. So we'll make a lot of reference to it when we are studying company law, when we are studying company law. So apart from the case laws, also the Companies Act is actually one of our major references. So if you look at the Companies Act of 2015, companies have been classified or categorized into 5 classifications. So we have number 1, a limited company, So this is related to the concept I've just explained, a limited liability in a company. So we are going to see deeper what we mean by that. So we have what we call unlimited company. We have what we call a private company, and we have what we call a public company. So under limited company, they have split into 2. So you have a limited company, limited company by shares, and number 2, by guarantee. So we are saying there are 5 classifications. So I've told you we have limited, unlimited, private, and public. Under limited, they're split into 2, making them 5. So we have by shares, limited by shares, and limited by guarantee. Then, of course, we have other classifications. So you can have other classifications. For example, in this case, we could actually be able to talk about a corporation sole. So that is number 1. You can be able to talk about a corporation aggregate. You can be able to talk about statutory corporations. You can be able to talk about a holding company and a subsidiary or holding companies, stock subsidiary companies. And we can actually also be able to talk about a private company. Can be able to talk about a private company. So that is number 5. Not a private company, but a foreign company. You can be able to talk about a chartered company. So these are other classifications. So you won't find them under the Companies Act. So there are other classifications that you can actually be able to use to classify companies. So I've told you corporation sole, corporation aggregate, statutory corporations, holding company or subsidiary companies. Then we can have foreign companies and chartered companies. So basically, we are going to go through them one by one, explaining one by one, so that you can actually be able to understand what we mean by these particular classifications. So we'll start with these ones, classifications under the Companies Act. So I've told you, number 1, we have a limited, then number 2, we have unlimited. So they are related in a way. So what I mean by a limited company, just as I've explained, under the characteristic that you're talking about, limited liability. In this type of a company, it is whereby your liability of you as a shareholder or as an owner of the company is limited. Your liability in that particular company is limited. So that is the simplest way basically to be able to explain or basically define this particular concept we are talking about, limited company. So you are saying in this type of a company, your liability as a member or a shareholder or an owner is limited. And what do I mean by limited? Your liability is up to a particular extent. The extent is actually already defined, and it can be defined in 2 ways. It can be defined by the number of shares you have in the company or by guarantee. So under limited company, we can have two types of companies or classifications: a company limited by shares, and number two, a company limited by guarantee. What we mean by a company limited by shares, it is a type of a company whereby your liability over as a member of the company is up to the amount outstanding on your shares. This simply means that, for example, as I've told you, you have shares worth 100,000 in the company. You've only been able to pay for 80,000 of the shares. It simply means that your liability in this particular company is only for the outstanding amount of 20,000. So it means that if the company is to be liquidated today, you'll only be called upon to pay your outstanding amount on your shares, which basically will go up to the shares you actually own in the company. So your extent basically is up to this particular 100,000 worth of shares. So we are saying a company limited by shares, it is a type of a company whereby your liability as a member of the company is up to the amount outstanding on your shares. You can only be called upon to contribute the amounts that are actually outstanding on your shares. They won't go beyond or basically ask you to bring in your personal assets. They won't go beyond the shares you actually own in the company. So a company limited by shares is a type of a company whereby the liability of you as a member of the company or as an owner of the company is up to the amounts outstanding on your shares. That is what we mean by a company limited by shares. A company limited by guarantee. In this type of a company, your liability as a member of the company is up to the amount you've given guarantee you'll be able to contribute in case this company is liquidated. I've already explained to you briefly what is liquidation. It is basically that process undertaken to end the life of the company. During this particular process, all the creditors, all the suppliers of Tuskys will be listed, and these creditors must be paid their due amounts before the life of Tuskys is to come to an end. So we are saying, for example, in this case, if Tuskys is a company limited by guarantee, you as a shareholder at Tuskys or as an owner at Tuskys, you can only be called upon to contribute those amounts you've guaranteed on formation. You'll be able to contribute towards the assets in case the life of that company, the life of Tuskys, is to come to an end. So in a company limited by guarantee, it is a type of a company whereby the liability of a member of the company or you as a member of the company is up to the amounts you've guaranteed you'll contribute towards the assets in case the company's life is to come to an end or it is liquidated. So you simply state in the memorandum of formation of the company that I've guaranteed in case this company is liquidated, I'll contribute 6 million towards the assets. These amounts will be utilized to pay the liabilities of the company. So that's what we mean by a company limited by guarantee. A company limited by guarantee. So that's what we mean by a company limited by guarantee. So we've said a company limited by shares, your liability as a member of the company is up to the amounts outstanding on your shares. You'll only be called upon to contribute those amounts outstanding on your shares to be utilized to pay the liabilities in case the company is actually liquidated. If it is limited by guarantee, you know what is guarantee. You give an assurance on formation that me as a person or as one of the members of the company, I'll actually be able to contribute 6 million towards the assets to be utilized to pay the liabilities of the company, So what you must actually be able to realize that at this particular point, in a company limited by guarantee, there are no shares. You can't acquire shares because there are no shares. You simply give a guarantee or an assurance that basically I'll give, for example, 6 million towards the assets in case the company is actually liquidated. You don't acquire shares because there are no shares. You only give guarantee as to how much you can actually be able to contribute towards the assets in case the company is actually liquidated. So the capital, the share capital of the company is usually an important resource, especially for the creditors of the company in case the company is liquidated, because that's basically where they'll get the resources to be able to pay the creditors or the liabilities of the company. So that's why if it doesn't have shares, there must be a guarantee as to how much members of the company are going to contribute towards the asset in case it's actually liquidated, so that the creditors can actually be secured. So this share capital is actually very important as a fund of last resort to the creditors in case the life of the company is to come to an end. So if there are no shares, there must be a guarantee given by the members of the company. Unlimited company, it is now the opposite. It is now the opposite of a limited company. In unlimited company, this is whereby your liability of a member is actually, you as a member is actually unlimited. It simply means that in case of liquidation, you as a person or you as an owner of the company, your personal assets can be attached or basically utilized to pay the liabilities of the business. So if the assets of the business are not actually, or the company are not actually quite enough, the shareholders or basically the owners can be called upon to attach their own assets, for example, motor vehicles or maybe land owned by them personally, so that they can actually be utilized to basically pay off the liabilities of the company. So that is for unlimited companies. So most people basically will actually prefer to operate as a limited company. So that's why most companies, you'll see they end with the word limited. They end with the word limited. Simply means that the liability of members in that company is actually limited. It goes up to a particular extent, either the number of shares they have in the company, or basically maybe by their guarantee or the guarantee they have given, they'll be able to contribute towards the assets in case the company is actually liquidated. So for unlimited company is a type of a company whereby the liability of a member is actually unlimited. In case of liquidation, this particular member can be called upon to attach his or her personal assets to be utilized to pay the liabilities of the company. That is what we mean by a company that is actually unlimited. A private company. So the key characteristics of a private company includes, so these are type of a company whereby membership is actually 1 up to 50. So for a private company, so membership is 1 up to 50. This type of a company also, transfer of shares is restricted. This type of a company also, the minimum number of directors is 1. Minimum number of directors is 1. This type of a company also cannot invite members of the public to buy into its shares. To buy into its shares or to buy its shares. To buy into its shares. So that's what we mean by a private company. So it is almost quite the opposite of a public company. For a public company, so that is the last classification under the Companies Act, this one. For a public company, this one, the minimum number of members is 2. Minimum number of members is 2. And there is no maximum limit. There is no maximum limit. In this type of a company, there is what we call free transferability of shares. Free transferability of shares. There's what we call free transferability of shares. Also, in this type of a company, the minimum number of directors is 2. Minimum number of directors is 2. This type of a company can invite members of the public to buy into its shares or to subscribe for its shares. It can invite members of the public to subscribe for its shares. To subscribe for its shares. So that is what we mean by a private and a public company. So for a private company is a type of a company that can basically be owned by 1 up to 50 persons. But for a public company, The minimum number of members is actually 2. Is 2, and there's normally no maximum limit. So it can be 1 million members, it can be 2 million, it can be 40 million. So there's usually no maximum limit set for a public company. But for private companies, that type of a company that can be formed either by me or you to operate as a form of business. So you can simply go ahead to the registrar's office and set up your own private company. So for a public company, you're also saying that there is normally what we call free transferability of shares. So what we mean by public company, these are companies that are mostly listed on the securities exchange. So you can go to the stock market and actually basically buy your shares, and they can be freely be transferred to. There are a lot of restrictions put in terms of shares being transferred in a public company from one person to the other. But for a private company, there are a lot of restrictions. What we mean by there are a lot of restrictions, it doesn't mean you can't transfer your shares. You can't be able to transfer your shares in a private company. But of course, the register of companies will basically require to fulfill a lot of requirements before the shares can actually be transferred. For example, in this case, there must be a share transfer form. It must be signed by both parties. It must be signed by, for example, a company secretary before these shares can actually be transferred from you as a person in a private company to the other person. So there are a lot of restrictions in terms of transfer of shares in a private company. The minimum number of directors in a public company should actually be at least 2. But for private company is only 1. So this simply means that when you form your own private company as a sole person, basically it means that you'll be the sole director. You'll be the sole director. But since in a public company, you are saying that there are at least 2 members, it must have at least 2 directors. It should have at least 2 directors before it can be registered. It can be registered. For a public company, it can be able to invite members of the public to buy into its shares. So it can be able to invite members of the public to be able to buy into its shares. But for a private company, if you own a private company, you can't go out publicly. For example, issuing out a prospectus, inviting people to buy the shares of your private company. You can't be able to do so. But in the case of a public company or a listed company, it can give out what we call a prospectus, invite members of the public to be able to buy into its shares. That is what we mean by a private company and a public company. So sometimes they could ask you in a past paper question or exam that distinguish between, when you start looking at them, you'll be able to see, distinguish between a private company and a public company. So you can use these points as distinctions or ways through which you can actually be able to differentiate the two. You can be able to differentiate the two. You can simply be able to say that membership for a private company is 1 up to 50. For a public company, it is actually minimum is 2 and there's no maximum limit. For a private company, there's a restriction on transfer of shares. In a public company, you can freely transfer your shares. In a public company, you must have at least 2 directors. In a private company, you must have at least 1 director. So those are some of the points you can actually be able to use to differentiate between the two. So those are the classifications of companies under the Companies Act. So sometimes in the exam, they could ask you the question specifically. State 5 classifications of companies under the Companies Act. So if they ask for such kind of a question and it has been tested, you simply basically list the ones you've just gone through. So if you look at the Companies Act of 2015, these are basically, they have actually been able to classify companies or categorize the types of companies or categorize the types of companies. So I don't know if there's a question up to that particular point, because I want us to go to other classifications of companies, So I can see George here. George, do you have a question up to that particular point? George, do you have a question? I can see Hassan. Hassan, do you have a question? What about Michael? Michael Munga, do you have a question? So I can see Winnie had given another point there. So another classification, another characteristic of a company, which we had not mentioned, I think it's number 8, it can be able to, it has the capacity or ability to sue, ability to sue. You can add there sue or be sued in its own name, in its own name. So it has that particular capability or ability to sue or be sued in its own name. So for example, in this case, if there's an action that must be brought before the court of law, it will basically be in the name of the company and not the shareholders. So that's what we mean by the capacity or capability to be able to sue or be sued in its own name. So if the company is to take an action against another party, it won't be in the name of the owners or the shareholders. It will be in the name of the company itself. So that is another characteristic of a company. So you can add that one as number 8. So I can see Nemo Lucy. Do you have a question? What about Victor?
No question. I think that has been clearly explained.
Sawa. What about Winnie? None. Winnie says none. So I think we can be able to proceed on other classifications of companies, So other classifications of companies. Other classifications of companies. So I've said we can have other classifications, including like corporation sole. We can have corporation aggregates. We can have statutory corporations. We can have holding companies or subsidiary companies. We can have foreign companies. We can have what we call chartered companies. So we'll basically go through them one by one. What we mean by a corporation sole, it is an independent office that is normally held by a sole person, whereby in this particular office, we have what we call succession. So the way this particular office actually operates, it will be seen or actually be viewed as being a company or a corporation. So what we mean by a corporation sole, we simply say that a corporation sole is an independent office that is owned by a sole person with some form of succession in this particular office. Or the examples we normally give, so the best examples we normally give is, for example, it is the office of the president, You can give an example like the office of the president, like the office of the bishop, office of, for example, the attorney general. So the way this office actually operates, they're actually very independent from the holder. When the holder actually goes home, basically his term comes to an end, he doesn't go home with the office. The office basically remains, and of course, there is succession in the office. So that's why they're basically viewed as being corporations or actually companies. So when you talk about a corporation sole, it is an independent office that is actually held by a sole person at a time. And of course, there's what we call succession in the office. So like the office of the president, when this particular president of ours, actually his term comes to an end next year, basically he will go home and leave the office, which will basically be succeeded by another person. In this case, for example, if this particular office has certain provisions or basically assets, he won't go home with these particular assets. They'll basically remain under the office of the president. So how the office actually operates, if you look at it, it is basically like a form of a corporation or a company. That's why it is normally categorized as being a classification of a company under what we call corporation sole. So like in the case of a bishop in a church, so this particular bishop basically won't go home with the office once the term actually comes to an end. He'll basically leave the office and basically it will be succeeded by another person. So that's what we mean by a corporation sole. The key thing we are saying, a corporation sole is an independent office that is normally held by a sole person each and every time. And of course, there's what we call succession in the office, e.g. the office of the president or the office of the bishop. If you basically state that, for example, in an exam question, basically the examiner will actually be able to know that this particular student knows what he or she is actually talking about. It is an independent office that is normally held by a sole person with succession in the office. So for example, you give now an example like the office of the president or the office of a bishop. Corporation aggregate. What we mean by a corporation aggregate, it is any form or type of a company that is actually owned by at least two persons. This company has all the unique characteristics of a company. So long as it is actually owned by at least two persons, it will basically be categorized as being a corporation aggregate. It will be categorized as being a corporation aggregate. So it is any type of a company or any form of a company that basically is actually owned by at least two persons with all the other characteristics of a company in existence in this form of corporation. It will be categorized or basically classified as a corporation aggregate. So one thing that should actually come to your mind, basically these are just classifications. They are just categorizations. It doesn't mean that when a company is actually a corporation aggregate, it cannot be categorized as being a private company. Even if, in this case, what you can actually be able to gather what I'm talking about, a corporation aggregate. What I mean by this, for example, a private company that is owned by 5 persons, it can be categorized as a corporation aggregate. Because what have I said about a corporation aggregate? It is any type or form of a company that is owned by at least 2 persons with all the other characteristics of a company in existence. It will be categorized as being a corporation aggregate. A public company that is owned by 10 persons, it can be categorized also as a corporation aggregate. These are simply just classifications. So therefore, it doesn't mean if a particular company falls in a particular category, like the other side under the Companies Act, it doesn't mean it cannot actually basically fall under these particular classifications. So they are just general classifications as to how companies can actually be categorized. So that is what we mean by a corporation aggregate. Statutory corporations. What are statutory corporations? These are basically some of the ones that you normally hear people talk about, parastatals. So they normally say that I just want to get employment in a parastatal, an entity owned by the government. There is no a lot of work. You leave work at maybe 4, you report to work at maybe 9. Basically, maybe on Friday, you leave the office by 1. Saturday, you don't report. There are a lot of hefty allowances. If you travel, you are given a lot of allowances. So I want just to get employment in a parastatal. So that's why some people, what some people normally say. So those parastatals are the ones basically we call statutory corporations. So what is a statutory corporation? A statutory corporation is basically a corporation that comes into existence through an enactment or basically an approval of an act of parliament. So there must be an act of parliament forming that particular statutory corporation, or basically that particular corporation. So another characteristic about these particular statutory corporations, or basically these corporations we are calling statutory corporations, so you say number 1, it comes into existence through an enactment of an act of parliament. Number 2, that act of parliament sets out the management structure of this statutory corporation or this particular corporation. Then number 3, they are majorly formed to provide essential services to to the citizens. Now, in this case, I can be able to mention some of the examples of statutory corporations. For example, Kenya Port Authority, Kenya Broadcasting Corporation, Kenya Railways Authority, Kenya Pipeline Corporation. All those ones are basically statutory corporations that came into existence through an enactment of an act of parliament. This act of parliament set out, or basically set out, the management structure of these particular statutory corporations. So they'll basically say, for example, we'll have a board. If you look at the act of parliament that formed them, we'll have a board of directors that will be headed by a chairman. It will have maybe a managing director. So basically, clearly, it will set out the structure of that particular corporation. Number three, we are saying they are majorly formed to provide essential services to the citizens. So their primary objective is normally to provide essential services to the citizens. Profit making is just a secondary objective. It is not their main objective. Their main objective is to provide essential services to the citizens. So they are normally funded by the treasury. So they'll be funded by the treasury. So each and every year when the budget is actually being read out. So for example, if that particular statutory corporation falls under a particular ministry, certain amount of money will be allocated to the statutory corporations. So that's basically where they get, for example, their capital. So they'll be funded by the treasury. So you've said profit making is just a secondary objective, but of course, if they make profits, they will be remitted to the treasury. So they'll give that money to the government at the treasury because it's the one that actually normally funds them. But their main objective is normally to provide essential services to the citizens, essential services to the citizens. Profit making is just a secondary objective for them. Then another thing is that they don't undergo the normal liquidation process, whereby we are saying they gather all the assets, they list all the creditors. Then, of course, after that, basically the company now presents the liquidation report to the register, then the company is dissolved. For them, they are actually very unique. Their life can only come to an end if that act of parliament that formed them has been revoked or basically cancelled out or basically superseded by another act of parliament in that case. But so long as the act of parliament is still in existence, it simply means that the life of the corporation is still in existence until when that particular law that formed them has been revoked or basically cancelled out or superseded by another act of parliament. So those are some of the key characteristics of what you are calling a statutory corporation. So there are type of corporations that normally come into existence through an act of parliament. This act of parliament sets out their management structure, and of course, they are majorly formed to provide essential services to the citizens. Profit making for them is just a secondary objective. They are normally funded by the treasury. In case they make any profits, these profits will be remitted to the treasury. So sometimes in the exam, they could ask you, state 4 characteristics of a statutory corporation. Remember what the teacher said. The teacher is saying that statutory corporations will come into existence through an act of parliament. This act of parliament, number 2, will set out the management structure. They are majorly formed, number 3, to provide essential services to the citizens. Profit making for them is just a secondary objective. They are funded by the treasury. If they make any profits, these profits will be remitted to the treasury. They don't undergo the normal liquidation process. Their life can only come to an end when the act of parliament that actually formed them has been revoked or basically superseded by another act of parliament. That is what we mean by a statutory corporation. Then number 4, a holding company or a subsidiary company. What is a holding company? So this one, basically you'll learn more about it in financial reporting, how basically to prepare their financial statements for holding companies and what is actually a subsidiary company. What we mean by a holding company, it is a type of a company whereby it has a stake or ownership in another company. So therefore, it has control over the activities of that other company. So in this case, we mean, for example, we could be having a company, let's say, for example, company ABC. It has acquired, let's say, for example, 60% of company XYZ. XYZ becomes now the subsidiary, while this one becomes now the holding company. So what we mean by a holding company, it is a type of a company which has ownership. It is actually able to control the activities of the other company as a result of the ownership or stake that it actually controls in that company. So remember, if you have more shares in the company, you have a lot of voting rights. In this case, for example, if the 7 of us basically are members in a company or are shareholders in a company, and let's say, for example, one of us basically has ownership of shares that are worth 70% in the company, all the others we are sharing 30%, this person will have a bigger say than all of us. So the voting rights are normally attached to the number of shares you hold in the company. So in this case, if the holding company has 60% of the shares or has ownership of 60% of the shares, it simply means that it is actually able to control the activities of that other company through what we call voting. So remember, we've said a company is a person on its own. So don't be surprised that a company can be able to have ownership in another company, because you've said the company has the capability or the capacity to own property in its own name. So in this case, the company can be able to own shares in another company worth 60%. So therefore, it becomes a holding company. So for a holding company, it is a type of a company that is actually able to control the affairs or activities of another company through ownership or stake or control of the majority shares of that other company. That other company now becomes the subsidiary. So that's why you are relating it to the subsidiary. So in financial reporting, basically, we'll be taught how to prepare the financial statements in such circumstances whereby we have a holding company and a subsidiary. How do you combine or consolidate the financial statements? So that's what we mean by a holding company. What is a foreign company? So a foreign company, sometimes foreign companies are normally basically known as companies incorporated outside Kenya. So these are simply companies that were originally basically registered initially not in Kenya, but of course they have sought operations or they have sought base to operate in Kenya. So they'll be registered at the registrar's office as foreign companies. So they were companies that initially were not incorporated in Kenya. They were originally incorporated in other countries. For example, it could be in the United Kingdom. Then, of course, they want to seek operations in Kenya. They'll be registered in Kenya as foreign companies. So that's what we mean by a foreign company. So companies initially not incorporated in Kenya, therefore they have sought to operate or have base of operations in Kenya. So they'll be incorporated or be registered as foreign companies in Kenya. Most of them, sometimes are some of these particular international companies that we actually have in Kenya. But we'll see that most of them, they'll basically sought to register as resident companies instead of foreign companies, because foreign companies have a lot of disadvantages. So if you've been in a public finance and tax class, you've been told that their taxation rates are normally, I think, a bit high. So it's 37.5% their corporation tax, but for a local company, it's 30%. So you can see if you register as a foreign company, you'll be disadvantaged in terms of the corporation tax you'll actually be paying. So most of them will actually opt to seek operations as resident companies so that they actually avoid a lot of taxation or the tax rate actually being high in terms of the corporation tax. So that's what we mean by a foreign company. Chartered companies. So there are companies that come into existence or corporations that come into existence through an issue of a charter by an authorized person. Examples we can actually be able to give is, for example, private universities. So they come into existence through an issue of a charter or authority by the president. So sometimes you hear the president has given out a charter. So that particular private university will actually operate as a corporation. Its existence does not actually depend on the life of the vice chancellor or maybe the students there. So that's why they can actually be able to exist for a very long period of time, over 100 years, and they're actually basically still in existence. So that's why they are viewed as being forms of companies or classifications of companies or forms of corporations. So a chartered company, it is simply a company that comes into existence through an issue of a charter by an authorized person. So what we mean by a charter is simply an authority to be able to operate or carry out a particular service or activity. So once that charter is given by the authorized person, then of course, it will actually basically continue to operate as a corporation. So this particular means of forming companies was basically borrowed from the common law or basically from the United Kingdom, whereby the Queen used to basically give out charters for companies to be able to operate. So it was adapted. And of course, private universities or universities in Kenya, can come into existence through the issue of a charter by the president, issue of a charter by the president, who is actually the authorized person to be able to give up that particular authority. That's what we mean by chartered company. So those are the other classifications of companies. So remember, I've told you, if the examiner basically clearly specifies that, state the classifications of companies under the Companies Act. Don't mention these ones, mention the other ones, the first ones you've learned about: limited, unlimited, private, and public. But basically, if it's just open, then you can just mix them in whatever way you want. You can state corporation sole, corporation aggregate, you mix with private, like that, like that, like that, like that. So with these other ones, sometimes they could ask in the exam, differentiate. This one, they like it: corporation aggregate and corporations sole. What is the difference between corporation aggregate and corporation sole? So corporation sole, as I've told you, is an independent office that is normally held by a sole person at a time, and there's usually what we call succession in this particular office. Corporation aggregate, any form of corporation that is actually basically owned by at least two persons, and all the other characteristics of a company are in existence. For example, ownership of property, succession. It simply means that that particular corporation can be categorized as being a corporation aggregate. Or they could ask you, define a holding company, or they could ask you, state the characteristics, 4 characteristics of a statutory corporation. So eventually, when I start looking at the past papers, which won't be long from now, basically we'll be able to see how they test the questions in the exam, Those are the types or classifications of companies. So I want us to look at the principle of separate legal entity and the veil of incorporation. So that's what I want us to look at. So the principle of separate legal entity and the veil of incorporation, and the veil of incorporation, and the veil of incorporation, and the veil of incorporation. So as I've explained, what we mean by the principle of separate legal entity is basically whereby you are talking about the company itself, and the owners being two different persons under the law. So the company will always be a separate entity from the owners, and it is actually explained by the rule in Solomon versus Solomon and Company Limited. The rule in Solomon versus Solomon and Company Limited. So this is basically the rule that clearly explains that a company is a separate entity from the owners. So that's basically what it explains, that a company will always be a separate entity from the owners. It will be viewed as being a person on its own from the owners of the company. So once the company is actually formed, there's usually what we call a veil that is created. So since you're already saying there's a veil that is created, a shield that is created between the company and the owners. So the company will just be a person on its own, while the owners will actually also be persons on their own. So as a result of that, the company is actually able to undertake or have different capacities as a result of the principle of separate legal entity. For example, we've already mentioned them: capacity to sue or be sued in its own name, capacity to own property in its own name, perpetual succession, limited liability, capacity to contract. All those come out as a result of the company being a separate entity from the owners. So whereby there's actually already created a shield or a veil in between the company and the owners of the company. So as a result of that, it becomes a separate entity. So this particular case law simply states or basically explains the principle of separate legal entity, the rule in Salomon versus Salomon and Company Limited, which I've already explained. It talks about a Jewish guy known as Solomon having migrated to the United Kingdom, set up a business that where basically the relatives got interested. They eventually joined the business, and as a result of that, it was no longer a sole business. It was converted into being a company. So all these particular relatives, the wife and the sons, became shareholders in the company, and also Solomon. But you've said Solomon was given an extra stake in the company. He was given debentures worth £10,000 in the company as a result of having transferred his own assets from the sole business to the company. So therefore, he was a creditor of the company. But during liquidation, when this particular company faced difficulties, other creditors, not Solomon, other creditors in the company claimed that Solomon and Company Limited are just like one and the same person. So how comes Solomon is being listed as a creditor? The court ruled that Solomon himself and the company itself are two different entities or persons. Therefore, Solomon is entitled to also be seen as being an owner of the company and also a creditor of the company. So he's entitled to be paid his due amounts on the debentures worth £10,000. So it simply clearly states that a company will basically be a separate entity from the owners of the company, will be a separate entity from the owners of the company. But we are saying that there's normally a veil that is created between the company and the owners after formation or incorporation. But what you have to realize is that this particular case law or this particular principle, it has what we call exceptions. It doesn't actually prevail always, and under certain special circumstances, the courts or courts of law have been forced to lift this veil of incorporation and view the company and the owners as being one and the same person. We've said under special circumstances, there are exceptions whereby this rule doesn't prevail always. Certain times, the courts of law, if there's a case before the courts of law, they have been forced to lift the veil and view the company and owners as being one and the same person. The most dominant one that can actually be able to bring forth now is, for example, if the company is being involved in fraud. They'll simply bring before the court of law the owners of the company and not the company itself, because the persons who are perpetrating fraud in that particular company are the owners. So that is an exception whereby now, basically, they won't view the company as being a person on its own from the owners. They have to basically go to extent to see who are the people behind this company who are perpetrating the fraud. For example, if the company basically has been formed, number two, to be involved in evasion of taxes or payment of taxes. In this case, if Keroche Breweries has been accused of basically not being able to pay revenue or taxes to the government, they'll bring in to the court of law this person known as Tabitha Karanja. And I think this one you've seen on the televisions. So they basically go behind to look at who are the people behind the company. They won't just bring Keroche as a company to the court of law. So because you are saying it can still be sued in its own name, but you are saying under exceptional circumstances, the court has actually been able to lift the veil and view the company and the owners or the people behind the company as being one and the same person. So the most two dominant examples are brought forth at this particular moment. I've said, for example, if the company is involved in fraud, or for example, if the company is involved in evasion of payment of revenue to the government or taxes to the government. So sometimes we normally say these are the exceptions to the rule in Solomon versus Solomon and Company Limited, or exceptions to the principle of separate legal entity, whereby now the company won't be viewed as being separate from the owners. They'll be viewed as being one and the same person. They'll be viewed as being one and the same person. So we can take a break of like a minute Then I look at other exceptions under this particular rule. We are calling the rule in Salomon versus Salomon and Company Limited. So there are several of them. There are like 8 or 10 there. Then one by one, you see the exceptions under which the veil or the exceptions in the rule of Salomon versus Salomon and Company Limited. So I think we can go through the other exceptions. Time of this. I want to show you a screenshot that will go through this. Some of them have a few checklists, so you can be able to look at them. So if we can look at we have the first one there, determination of the enemy character of the company, determination of the enemy character of the company. So what I mean by enemy character is that so it to be determined when a company is an enemy character, they look at the people in de facto control, or those basically who are controlling the activities of the company, and basically they'll be owners of the company. So if you are to determine a particular company is actually an enemy character in Kenya, for example, they look at the people or basically the owners of that particular company. So if company ABC registered in Kenya and company XYZ registered in Uganda, for it to be determined whether XYZ is an enemy character to ABC as a company or is an enemy to ABC, they look at the people who are actually controlling the affairs of XYZ. So if these people controlling the company XYZ are Ugandans, and these Ugandans at this particular moment or time, Kenya is actually at war with Uganda. It simply means all Ugandans are actually enemy characters in Kenya. So if this company is being controlled by the Ugandans, this particular company becomes an enemy character. So you can actually be able to see they go beyond to look at who are the people in de facto control of this particular company. If they are enemy characters, the company therefore becomes an enemy character as a person. It is explained by a case law known as Daimler Company, basically Daimler Company Limited versus Continental Tires Company. It is a case law of 1914. So if you can remember very well, around this particular time, there was what we call World War I. So those who have done history, you've learned that the World War I happened between 1914 and 1916. So you can be able to see on your screen, hope you can be able to see the screen very clearly. We are saying one of the exceptions under which the court might lift the veil of incorporation is number one, for example, the determination of an enemy character of the company. So they are saying a company may assume an enemy character when people in de facto control of its affairs are residents in an enemy country. What we mean by an enemy country, as I've told you, if Kenya and Uganda are actually at war, Uganda becomes an enemy country. And therefore, all Ugandans in Kenya will become enemy characters or enemy persons because we are actually at war with Uganda as a country. So in such cases, the court may examine the character of the persons in control of the company and declare it an enemy character. So they look at the people in control of the company. If they are enemy characters, these persons, the company also therefore becomes an enemy character. The owners of that company are actually enemy characters. The company itself now also becomes an enemy character. So if you look at that particular case law, it says Daimler Company was incorporated in England, but all except one of the shares of the company were held by persons resident in Germany, while the secretary who held one share was of a British origin or citizenship. During the First World War, where Britain and Germany were on opposing sides, Daimler Company Limited commenced an action for recovery of a trade debt against Continental Tires Company Limited. So Continental Tires Company Limited was a UK company. It was fully owned by citizens from the United Kingdom or basically from England. But Daimler Company Limited, you can actually be able to see, it was a Germany-owned company. And Germany and United Kingdom were actually at war. This simply means that all Germans had become enemy characters for England or in England. Therefore, any company that was being controlled by Germans, for example, in this case, Daimler Company Limited, which was being controlled by Germans, was an enemy character to Continental Tires Limited. So they commenced a recovery of a trade debt from Continental Tires, which was a United Kingdom-based company or owned by United Kingdom citizens. So it was held that the company was an enemy and payment of the debt to it would amount to trading with an enemy, and therefore the company was not allowed to proceed with the action. So this Daimler Company Limited, which was being owned by Germans, had commenced recovery of a trade debt. A trade debt simply basically they supplied items to Continental Tires, and of course Continental Tires had not actually paid. So therefore they were not actually able to recover the money because payment of that particular amount would have amounted to payment of an amount to an enemy character or an enemy company. So you can be able to see, for it to be determined whether Daimler Company Limited was an enemy character, the court had to lift the veil and of course look at the people in de facto control of Daimler Company Limited. Since they were enemy characters, these persons, therefore Daimler Company Limited is now being affected by them, and therefore it also becomes an enemy character. So those are some of the circumstances, or one of the circumstances whereby the court can be able to lift the veil and actually be able to set that the company and the owners are being one and the same person. So that's what we mean by determination of the enemy character. So it is explained by that particular case law known as Daimler and Company Limited. Number two, we have where the company is formed for fraudulent or evasion of contractual obligations. So with the companies being involved in fraudulent activities or maybe corruption activities, so they won't view the company in isolation. They look at the people behind it because they're the ones who are actually perpetrating that particular fraud. So they can be able to lift the veil and of course view the company and the owners as being one and the same person. So if the company is involved in fraudulent activities or basically fraud, then it can actually be viewed as being one and the same person. Then it is explained by those particular two case laws. So we have Jones versus Limpman, and of course also Guilford Motors Company versus Horn. Maybe you can look at the one about Guilford versus Horn. So Horn was appointed a managing director of the company on condition that he will not at any time solicit or entice away the customers of the company. He, however, formed a new company to carry on the same business. The new company solicited the plaintiff's customers. Guilford Motors brought an action for injunction, or basically to stop Horn and the company. An injunction was granted both against Horn and the company, as the company had been formed to enable the defendant to breach his obligation against the solicitation. Number three, determination of the residence of the company, especially in terms of taxation. So it is explained by that particular case known as De Beers Consolidated Company versus Ho. So De Beers is a company that is basically carries out operations in the South African regions. So they have investments in mines, beer manufacture. So they have a lot of investments in the South African region, in Botswana and South Africa as a country. So there's this particular tax expert known as Ho, who basically brought a particular argument before the court. Because what was happening in this particular company known as De Beers basically was carrying out its business activities, or basically registered in South Africa. But all times, the board of directors meeting, or basically the directors meetings, were normally held in the United Kingdom. So they never used to come to South Africa. So the question arose as to what is the residence of this particular company in terms of taxation. And that is the question that was actually brought by this particular tax expert known as Ho. So according to his argument, he argued that since this particular company's activities are being controlled in the United Kingdom, the managing directors or the board of directors are the ones who carry out or basically manage the activity of the company. They don't come to South Africa. They always carry out their board of directors meetings in the United Kingdom. So it was actually eventually ruled that since the company's affairs are actually controlled in the United Kingdom, therefore this particular company should actually be taxed in the United Kingdom. And actually this particular tax expert actually won the case. So in the case of determination of the residence of the company, especially in terms of taxation, they'll be able to look at the people behind the company. Where do they control the activity of the company? So the reasons of the company is determined by the fact of its control, where the company is controlled from, or where the management actually sits or carries out their activities. So De Beers Consolidated Company versus Ho, the company was incorporated in South Africa, and many of the general meetings were held there. However, most of the board meetings were normally held in London, the United Kingdom. The question arose as to whether the company was a British or South African resident for the purpose of taxation. This is the question that was actually brought by this particular tax expert known as Ho. It was held that the company was a resident in Britain because the board meetings were normally held in the United Kingdom or in the Britain. So that's basically what we mean by determination of the residence of the company in terms of taxation. They look at where the activities of the company are normally controlled. So that's basically where the company can actually be taxed. So protection of revenue. So this one basically I've already explained when I was giving examples. So if the company is formed to evade payment of revenue to the government, that is another situation or circumstance whereby the veil can be lifted and they look at the people behind the company. They are the ones who will be brought before the courts to argue, basically give out reasons as to why the company is not actually able to meet its obligations in terms of payment of revenue or taxes to the government. So protection of revenue of the government, or basically revenue to the government, can also be an exception or lifting of the veil of incorporation. Protection of public policy, for example, if the company is not operating according to the policies or requirements set out, e.g. if it is formed for illegal activities or maybe carry out activities like maybe prostitution. So the veil can be lifted and they look at who are the people basically perpetuating this particular kind of violation of a public policy behind the company. So where the number of members of the company has fallen below the statutory requirements. So in this case, we mean, for example, as I've clearly indicated, for a public company, the minimum number of members is actually supposed to be 2. But if it is determined that the company has been operating with only one person, in case of any liabilities or obligations, this person will be forced to meet all those particular obligations. So there won't actually basically be a limit towards his liability. So this person who has been operating the public company without observing the requirements in terms of the minimum number of members as per the requirements of the Companies Act will be obligated to meet all the obligations. So where the company is operating without meeting the statutory requirements in terms of membership. So for example, if it is a private company that is operating with maybe more than 50 members, it is not meeting the statutory requirements in terms of membership. So misdescription of the name of the company. So whereby there's any document that is issued out or given out by the company without clearly describing the name of the company on the document. It could be an invoice, it could be a letter, it could be an agreement. So any person who basically did that will basically be held personally responsible, any person within the company. So the company itself will basically not be accused before the court, but any person who gave out that particular document within the company without clearly describing the name of the company clearly will be held responsible for such documentation or document that has been given out by the company. The name has not been described properly on the document. Investigation of the company membership. We learn later on that sometimes investigations can be carried out on membership of the company. So in this case, they'll go beyond the company itself and of course look at the membership of the company or the owners of the company or who are behind the company. So in case the court sanctions or basically gives out an order for investigation of membership of the company, they'll go beyond the company itself as an entity and look at the people behind the company or who are the members of the company. So that's another situation whereby, of course, the veil can be lifted. We have preparation of group accounts. So as I've told you, learn in financial reporting that if we have a group of companies or we have a holding company XYZ that has ownership in another company ABC, whereby the ownership is 60%, they'll be able to consolidate or combine their books of accounts. So in this case, XYZ won't be viewed in isolation. Since it is a member also at ABC, they'll be viewed as being one and the same entity in terms of consolidating or preparing the same books of accounts. So this entity, the subsidiary ABC, won't be viewed in isolation. They look at who is the owner. The owner is XYZ. They'll combine their books of accounts. So in preparing the group accounts or consolidated financial statements, basically these entities, the owner and basically the subsidiary company itself, will be viewed as being one and the same entity. So the owners won't be viewed in isolation. They'll be viewed as being one and the same person. Fraudulent conduct of business. So if the company is involved in fraudulent activities, so that one I've already explained, the company will likely also be held responsible. Then prosecution of delinquent officers or members of the company. Even in the course of winding up, it appears that any past member or present officers or any member of the company has been guilty of any offense in relation to the company, the court may declare such a person to be liable for the offense. Then also, we can also be able to add another one whereby the subsidiary company acts as an agent. I think it is not listed here, where the subsidiary company, so we've said in the preparation of the group accounts, also whereby the subsidiary acts as an agent of the holding company. I think if you've learned about the law of agency or the contract of agency, we normally have two parties, the agent and the principal. Any activities of the agent will hold the principal liable. So any activities of the subsidiary company will hold the holding company responsible. So since the holding company is an owner in that company, he'll be held responsible if this particular subsidiary as the agent carried out a particular activity on behalf of the holding company. So where the subsidiary company acts as an agent of the holding company will be held responsible. The owner of the company, who is the holding company, will be held responsible. So where the subsidiary company acts as an agent of the holding company, the veil of incorporation also can be lifted, and they look at who are the owners. The holding company is one of the owners of the subsidiary company. So therefore, he will be held responsible for the activities of the subsidiary company where he is actually an owner. Those are some of the exceptions whereby the veil of incorporation can be lifted and the company and the owners can be viewed as being one and the same person. So as I've told you, we normally say exceptions to the rule in Salomon versus Salomon and Company Limited. Alternatively, we can be able to say exceptions to the principle of separate legal entity, or we can actually be able to say the lifting of the veil of incorporation. Those particular three terms can basically be used, for example, in an exam situation or in an exam scenario. They can be able to say, state the exceptions to the rule in Salomon versus Salomon and Company Limited. Alternatively, they'll say, state the exceptions to the principle of separate legal entity, or they could say, state how the veil of incorporation of a company can be lifted. You simply state all those particular points we've been able to go through. So I'm going to end there for this particular session. We can meet after like an hour, around 2, after like lunchtime, around 2 there. Then we do the other session. So I intend to wind up this particular topic and of course cover part of the second topic, which is formation of companies. So we've remained with a small bit of this particular topic, that is distinction between a company and other forms of business. Then we can start formation of companies. So you can go for your break. We'll basically meet again at around 2 to 10 there, 2 to 10 there. So you can have lunch. Then after that, we'll meet.